Article 10. When they send that amendment in, the state will determine whether they have to do another environmental impact statement and/or seeker, or comply with all their rules and regulations, which are similar, and take the place of seeker.
So the gentleman said that under the section that I read, that all affected persons have been approached and
They have to be
been
notified
told
in
that
writing.
about the possible effects of this? Is that true?
Here we go again. You're trying to put the cart before the horse. Until that local law is
No,
changed,
he's the one that said that
No.
all affected landowners have been informed.
informed of the existing situation, the existing application that's been approved. All of them have been informed. They don't have to inform anybody of anything yet because nothing has changed.
But you want to
As
change the
of
law.
tonight, when we're talking, nothing has changed. If in fact the town board passes the amendment to the local law, then something will change, and Analogy or whoever other wind developer comes in, which I've already been notified that there may be another one coming in. So I have a meeting on Thursday. Then they will have to send their amendment through Article 10 and do whatever is required under Article 10, and all the notifications, all the studies and everything that have to be done. If in fact they determine that they're going to change their existing application.
Question for Chip. How many 650-foot turbines are in this country operational right now? Excuse me?
I would say I don't know the answer.
One.
Don't know
And
the
it's an
answer.
experimental one in Texas. Texas A&M built this. So how can you do a seeker on a turbine that doesn't even exist except offshore?
So,
Are we supposed to be guinea pigs? Is this how it's going to operate?
Excuse me, sir, what's your name?
My name is Hans Dotzler.
Thank you.
so with respect to that, I do believe that there's a project operating in Maine with turbines that are 650
Where?
feet tall. And we'd be happy to provide that
Where?
information if it was helpful.
In Europe or the North Sea?
No,
Maine.
I said Maine.
No, there isn't. I did
So-
some research and I don't see
and with
anything
respect-
operational
With
at
respect to
650
the
feet.
assessment on the height, the Article 10, as you guys know, and as you said, Supervisor, that all the environmental assessment with respect to the turbines will be addressed in the amended Article 10 process.
You're doing a seeker on a machine that doesn't exist yet in this country. They're 20 miles off the coast of Europe.
If it's helpful for the board again, I mean, that statement's not true. There was a full Article 10 record developed for the Bluestone Wind Project, which has turbines proposed to be 670
Proposed.
feet in height. And there was environmental assessment, there were turbine brochures, there was all the information that was provided with respect to those turbine machines and the environmental impact review based on those heights.
Okay, thank you. Who's next?
Judy Hall?
My first question is going to be the same that it was last month, and I never did get an answer, but now I have more documents. Who prepared the law? Who prepared the EAF? There are no minutes or no record of a town board meeting to prepare any of these documents or talk about them ever in an open board meeting. I wonder who prepared all these documents.
The
that were given to
local
the
law was
planning
sent
board.
down, the request for the amendment to the local law was sent to Jeff Squires, our town attorney's office, for
Well,
him to,
Who made the recommendation? It was never discussed at a town board meeting.
I believe it was.
No, Chip came and asked to have you consider it. There was never if there was a special meeting, it certainly wasn't noticed or attended by anybody. And Martha has no minutes of the meeting. That's number one. Number two is, I believe, who completed the EAF that we have, that the planning board got last week.
That again was sent down to Attorney Squires' office. He reviewed it, took it over to the county planning board for their review for us.
Well, who filled it out? It's completed. The whole thing is completed.
Yep.
The planning board got total completed parts 1, 2, and 3. The town board has to complete their section. The applicant completes their section, but this isn't an applicant involved because that can't be. You can't change a law because someone asks you to change it. They need a variance, and that goes to the ZBA. And they have to exhaust all remedies before they would even consider asking you to change a law, or they should. So do we know who, Jeff completed all these documents?
The seeker's unsigned, the one that you sent me,
The EIS form.
the EAF one, parts 1, 2, 3, and 3A. Do not sign.
The other issue is, if nobody knows who prepared these documents, the town board is acting as lead agency for the EAF. You have to send a letter and give all involved agencies 30 days to declare that you're a lead agency, or that you want to be the lead agent. Other agencies, government agencies, have the right to say they'd actually like to be the lead agent for an EAF. And just in the resolution that was provided to the planning board last week, one of the whereas the proposed action amends the town zoning law, the town board classified the action as a type 1 action. The town board classified the action as a type 1 action under New York State Environmental Quality Review Act, SECRA, in parentheses, requiring a full environmental assessment form, full EAF. So this is stating that, and you gave this to us prepared, that you prepared these documents. I'd like to know when you prepared them. When was the meeting? Why was it not publicized? The other, a couple paragraphs down, this is all on page 1. Whereas pursuant to the town zoning law, the town board referred the proposed law and the EAF to the town planning board for report and did not receive any comments on the proposed law, or at least 30 days have passed since the law was referred. All that is totally incorrect. The planning board did not have it for 30 days. They never saw it till the meeting. I think Russ had it in email. It didn't, I
Yeah.
didn't have the documents
I
before
sent them
then.
a couple of weeks ahead of that to all of you guys, but it was just a wad of paper. I mean, it was much paper.
So all of this is totally incorrect. What you're planning to sign tonight, or what you're
Well,
proposing
this is the
to pass.
resolution for approving a negative declaration. This is not the local law.
Right, I know, but this comes before the local law. To do your due diligence and take a hard look before you can even do a negative declaration. And are you the lead agent? I don't think you did that
We're not
process
discussing the
correctly.
negative declaration right now. We're discussing the amendment to the local law.
Well, you have to do this before you do the law. That's how the process works, is all I'm trying to say. The hard look at what you're doing and whether it has an environmental impact is done before you pass the law, or even form the law. But the question still is that Fair and Winds did these documents, is my guess, and
Fair and Winds provided information, yes.
who put these documents together?
As I said, this stuff was sent down to our attorney Squires' office for his review and approval.
But who filled in the blanks? Who wrote all this?
This was
There's an
presented to
entire
me
package
as it
here.
is.
It's totally
And that's
filled
what I
out.
forwarded to,
But who
uh,
did you, who answered all these questions, is my question. Who filled out this document? Every single one of the boxes is filled out.
yep,
Well, who did it?
where did I received this email from? Was it, I think it was, you, Chip,
Yeah, like I said, well,
or your secretary.
yeah, that you had stated it, that we provided that, information to aid the board, as just proposed information for the board to review and do with as they will, right? And from that point then, as you stated, that it went then to the town attorney on the town board's behalf,
for his review,
Exactly.
any modifications thereof, and then also he's the one that took it over for the county planning board to review and comment on.
It's a proposed one, and the issues on the planning board changed since, so that would just be amended.
And that's why it's not signed, just because it's
Yeah,
not a
'cause it's
final
not done yet.
document. It won't be
It's
signed
not done
until.
until it's over.
Right. And just
Until you
to
vote
address
on
the lead agency comment, the town board, in a local law process, there
Doesn't
are
have
no
one.
other involved agencies, it's just the town board, so you don't have to go through a lead agency coordination. I think some of the confusion is associated with seeker review for a project development, and in the project development, you would have a planning board identifying itself as a lead agency, notifying the other involved agencies, designating itself as lead agency, and then proceeding through the seeker process. But on a local law, the town board doesn't do that, there are no other involved agencies, it's just you. And the decisions in that final document are yours, and ultimately, when you vote on it, I think Ms. Hall was the person who said this, you'll ultimately vote on seeker, that was correct, and then you'll vote to enact the local law, depending upon how you choose to proceed.
Anything else, Judy?
The responsibility of the town board is for the public's health and safety of its residents. And since Cheryl just said that she only received these documents today, you have obviously not been able to have taken a hard look at any of this. You haven't done any of your own due diligence, because when did you do it? You have to do it as a group. You have to discuss it in an open meeting with anybody who wants to be present, and that's not been done at all in this case. And if they want 650-foot turbines, they ask for a variance. And under the old law, they would ask for a special use permit, and that's what the planning board would be involved in.
But this is an Article 10 action.
That has nothing to do with that.
Oh, yes, it does.
Yeah, no, it doesn't.
No.
So I think, again, Ms. Hall's correct, that if you ignore Article 10, she's right. I mean, her experience with the other project may be coloring this, because you would have a project developer coming in, requesting a variance, obtaining the variance from a planning board, and then proceeding with the project approvals, whatever were required. And that's the zoning review, and that's in addition to the seeker review. And the planning board does all of that. But Article 10 was enacted after CPP was permitted by the town. And Article 10 says that all of those local procedures are preempted. So you don't go to the local body to get a variance. You don't go to the local planning board for a special use permit. And the local board or body doesn't do seeker. All of that's preempted by the state, and the state does that and has done that for the permitted Article 10 site, the Barron project. None of that's really relevant to what you folks are doing, because all that's in front of you right now is a local law. And you can do seeker on a local law, enact a local law, and that's the end of the process.
So when does it get signed?
So,
And if the town board approves or disapproves it.
Okay.
correct.
So someone from the town will sign the three-part seeker at that point?
Yes.
Okay.
And I don't
And they'll
believe
do
you
the
all,
regu-
And it doesn't
the
go back to
resolution for the
planning
negative
board?
declaration.
right, I don't believe you all have voted on that yet.
No, I haven't.
Right.
Okay.
That's pending the public hearing. The public hearing closes, you deliberate, you look at the hard look, and you make your determination.
But your project is approved by the Public Service Commission right now, based on our current local law, without any changes. You are asking, Chip came and asked this board to change the law. They should have gone to the ZBA and asked for a variance. Then, when that was denied, you exhausted that remedy, then you would go to your next remedy. You cannot legally change a law for a specific party.
We're not.
Well, they just asked you, they're the ones who asked you to do it. Why would you be doing this if Chip hadn't come in October and asked you to do it? You would have just said, oh, look at the new technology. Let's raise our law to 650 feet.
And would you have gone through that book and looked at it and decided to do that, Tom, without these
This
people?
book is September, October. This is a couple of months
And
ago.
did you look through that and then decide, oh, this is what we wanna do, and then Chip comes to you and this
Well, this is one of
this is
the,
how
yeah.
you react?
You recognize new technology. I mean, the existing law was passed in 2006. It's
Well,
2019.
maybe all this needs to be tabled until you get the new town board in there come the first of the year, because 3 of you are gonna be gone.
Judy, you got anything else?
No.
Who's next?
The next one was Patrick Wolf, but he didn't mean to sign on this
Right.
sheet. Hans?
Can I stand up?
Sure.
Well, here we are, 12 years later, and the good neighbors are back. That's what they called themselves when they came here in 2007, good neighbors. I'm not even gonna get into what you guys have done by bringing these machines into town as far as neighbors go. Can we just pass a law to keep the height at 500 feet for the next 50 years? Is that possible? It's not, is it? Because these machines are gonna constantly get bigger and bigger. The Germans just built an 850-foot turbine. If I was in your shoes, and if I was your boss, I would be saying, yeah, 10 years from now, I want to see an 850-foot turbine up there. I want to see the whole hill full of them, because that's where the money is. And 650 foot, there is not an operational 650-foot turbine in this country. So I don't know how you can, I don't know anything about town government, but I don't know how you can do studies on something that's not operational yet. Because I don't want to be a guinea pig. I live underneath these things. Okay? Half of my property has already been devalued because of the danger zone, which is called the setback. I call it the danger zone. Nobody's ever reimbursed me for loss of value. And you mentioned a couple of weeks ago, Chip, that you did all the studies on real estate values. How can you do a study on a machine that doesn't exist? Okay, I'm losing a lot of value to my house up there. And so I have a lot to lose here. So I prepared something today just to give you guys an idea of exactly how tall a 650-foot turbine is. What you guys are proposing is 430 feet high to the nacelle. That is the complete total height of what we have right now. It's 425 feet to the top of that blade. You're talking about bringing 650 foot, so the nacelle would be at the top of that blade. And I blew it up, and that's what you basically are looking at, with 650 feet. Okay? And 10 years from now, we'll be talking 800 feet.
It's the tip of the blade that's at 650, right?
Yes.
The tip of the blade's at 650, but what they're proposing, the nacelle right now is at
It's at 420.
260?
Oh, the current one, 256.
256. They're talking about bringing the nacelle of the 650 to the top of that blade. So the overall height of what we have now will be just where the gearbox is. Okay, and then you're talking about a blade diameter of 450 feet. I live right here. Okay, that's my house. I've already lost value to this land here because of what we have now, and we're going up 50 more feet in 2 years.
Is the tip of the blade part of the wind turbine?
Of course.
I'm glad somebody mentioned that, finally.
I'd like the town board to take a look at this.
I could see it.
And this setback right now is actually for what we have right now.
See, maximum height. They never mentioned maximum.
So,
If they increase it.
again, I really don't know how you can do a study on a machine that doesn't even exist. They have one test turbine in Texas. Thank you.
Trude?
I've been looking at this thing ever since we first started 13 years ago. And making them larger and changing the law. The law wasn't